These are some frequently asked questions about the governor in California and the Public Records Act. Where is California's law dealing with access to public records? It's actually found in the California Government Code. It is in um, Division 10 of Title 1. It's called the PRA, or the California Public Records Act. Does the PRA apply to the governor? The PRA contains specified types of public records and rules related to certain public employees and officials. In Article 1 of Chapter 14 of Part 5 of Division 10 of Title 1, it deals with the governor. So the answer is yes. What does Government Code Section 7928.000 provide? It basically says that with some specified exceptions, the Public Records Act does not require the disclosure of correspondence of the governor and correspondence to the governor or the employees of the governor's office, or any records that are in the custody or maintained by the governor's legal affairs secretary. Is there a limitation on the governor's exemption from the PRA? Yes. Public records cannot be transferred to the custody of the governor's legal affairs secretary in order to evade the disclosure provisions of the PRA. What does Government Code Section 7928.005 provide? It says that when the governor leaves office, either voluntarily or involuntarily, like a recall, that public records in the custody or control of the governor are to be transferred to the state archives as soon as practical. Is there a limitation on the governor's transfer of records to the archives? Yes, the governor may publicly write restrictions regarding public access to any of the transferred public records or any other writings that the governor may transfer that have not already been made accessible to the general public. And for how long can public access be restricted? Access cannot be restricted for a period greater than 50 years or the death of the governor, whichever is later. Are certain governor's office documents exempt from any limit on public access? Yes, there cannot be any restriction whatsoever with respect to enrolled bill files, press releases, speech files, or writings related to applications for clemency or extradition in cases that have been closed for a period of at least 25 years.